Good afternoon, people. I see people streaming into our virtual auditorium. Please use that chat to say hello and say hello where you're from. Say hello, this is James from Kimberley, or let's have a look where in South Africa you are. Please say hello there. There we go. Maria from Cape Town. How's it? Chris from Fishhook. Hello, Chris. Welcome. Okay, we've got the Cape Townians represented so far. Empangeni, Mossel Bay, more Cape Town there. Hi, Nikki. Oh, there's Van der Bijl. There's some Gauteng, Durbanville, Maritzburg, Belleville. That's wonderful. I was just saying at a webinar earlier this week, it is just incredible that in the last 5 years, it's really COVID that has catapulted us into this way of communication. And it really is remarkable to see everyone being able to join from your office desks or from your dining room table. That's incredible. Greenstone, Joburg, hello, Jonathan, welcome. Parijs, Vrystaat, welkom. Fourways, Joburg, hi, Lauren. We'll just wait a little while for the people to stream in, and we'll start at about 2:02. So whilst you're coming in, just say hello there. Hilton, KZN, hi, Mike. From George, there we go. Santon, Bronkhorstspruit. It's really lovely to see. I mean, I look at this LexisNexis logo that's on the screen. It's a little bit like everyone here from all corners of the globe as well. I don't know how one comes from corners of a sphere, but I always wonder where that statement comes from. All corners of the globe. No globe in my mind as a corner, but anyway. There, Leandi from Van Velden Duffy and Rustenburg. I hear you people on the radio quite often on Rechtsake. The Westville Durban. Hi, Lauren from Oudtshoorn. Right, it's 14:02. Let's start off while people are still trickling in, but let's just do a little bit of admin quickly. First and foremost, welcome everybody to this. I'm forgetting which number in our webinar series this is regarding deceased estates. I think we're probably down at about 8 or 9 already. Correct me if I'm wrong, Gavin. And today is really drafting of wills and the validity of specific clauses. So it's really exciting. A lot of people have registered for this webinar. So clearly it's front of mind. But just as I was going to say, a little bit of admin. The chat where you're saying hello and welcome and so on at the moment where you're from, that's great. If you've got any questions, however, please use the Q&A block. I know for those of you that have been there before, I'm probably sounding like a stuck record, but the Q&A is for the questions. So my colleague, Jamie Lee Lawrence, she will be answering those questions on the Q&A on the fly. If there's a common thread of questions that we see come up, we will address them in the open forum towards the end of the webinar. So that's really just the admin part of it. My two colleagues today, Gavin Buerta, not an unfamiliar face anymore. He really has been making a name for himself as the webinar guy when it gets to deceased estates. And he's joined by Jamie Lee Lawrence, both from LexisNexis. So thank you so much to our two panelists, but most importantly, thank you for all the attendees. So to the topic of today, to the drafting of wills, but specifically the validity of certain clauses. I'm always intrigued when one watches movies on the TV and it revolves around the death of someone there. It doesn't really happen in our country much, but is that reading of the will. You see the family gather in the living room, and there's usually the attorney there for the reading of the will. I don't think that happens much here, but two things happen here. The moment someone has passed away, the first thing they usually ask is, well, how did Granny die, or how did so-and-so die? And the second thing they ask is, did they leave a will? And I always think after the death, so post-mortem, it's a bit late to ask then or then to inquire whether one's drafted a will or not. It really forms a crucial cornerstone in the estate planning, is the drafting of the will, and it is supremely regulated. And it is of utmost importance that one gets this right. No matter what your wishes are, you have to get it right. So no one better than Gavin to guide us through getting it right. Gavin, I'm going to hand over to you, and we all look forward to hearing what you're going to show us today regarding the drafting of the wills and the validity of clauses. Thanks, Gavin, and over to you.
Thanks for the introduction, George, and good afternoon to all of our attendees. I am just going to share my screen from my side. George, if you can just let me know when you have a view of my slides.
It's busy loading, Gavin. But not quite yet. Yes. One more
Okay.
click, then it's on. There we go, on presentation. Go for it, Gavin. Thank you.
Perfect. Thank you so much, George. Like George mentioned, today we will be looking at drafting of wills, specifically their validity and a few of the important clauses that we can and can't include when we are putting that will together. So it's important to note that even though we understand the importance of the will in our estate planning, we do still have 75% of South Africans who die without a valid will. And even when we do have valid wills in place, we do often find that those wills are invalidated because they don't meet the validity requirements in terms of our Wills Act. So that's also then the main idea behind the webinar that we are having today, not only to assist with getting a will in place, but also to ensure that that will is valid and it can uphold after death. Okay, so let's just have a quick look at what we'll be discussing today, just a quick overview. We'll start off with just a definition to help us better understand what a will is and why we use it in estate planning. We'll then also look at the main legal requirements that we have for drafting a valid will. We'll then go over to our legal framework and just highlight some of the most relevant legislation and case law pertaining to the validity of a will. And then we'll look at the key aspects that also pertain to the will's validity. So here we'll look at legal capacity, voluntariness and testimony intent, and also the electronic signature of wills. We'll then look at some common clauses that we often find in a will, like our executors clause, our bequests and legacies versus our residuary clauses, our guardianship and testamentary trust provisions, revocation and clauses in wills, code.
Gavin, I don't know if you can hear me. George here. We're losing your voice there. I don't know if it's maybe just me or whether others are also losing. If you could maybe just move around there with the internet. Yeah, so other messages are coming in. We've lost Gavin there. No sound, lost audio. Okay, lost audio. Can people hear George? Please, in the chat there, just say if you can hear George. Okay, right. So people can hear me. We've lost Gavin. Okay, thanks. So obviously you can hear me, but we seem to have lost Gavin. There seems to be a connectivity. See, that's what Cape Town does, hey? Okay, so while Gavin is trying to reconnect, we'll just wait a little bit. Okay, so thanks. People can hear me loud and clear.
Hi, George. I'm back on my side. Can you hear me now?
Yes, Gavin, we can hear you. Do you want to load your presentation
Yes,
again?
let me just load up my presentation again. Apologies for that. It seems I just lost a bit of connection.
Okay, we've got the screen back up again.
Okay,
Yeah.
perfect.
Right, carry on, Gavin. Thank you.
So I think I left off at special considerations. So we'll also be looking at some special considerations to consider when drafting a will. So these will include our inheritance rights, exclusion of beneficiaries, and limitations on clauses that we can put into a will. Lastly, we'll look at a template of a will that contains most of these provisions that we are looking at today, just for an overview of how exactly we can implement what we learned today into a document. Okay, so let's get started with just a better understanding of what a will is. For definition, we can, of course, look to our Wills Act, which you can see there's quite an old act. It's all the way from 1953. It has been amended quite a few times in between. So when you look at that act, also just make sure that you read the most up-to-date version of it with all the amendments included. From the Wills Act, we can see that the definition of a will would be a legal document in which a person, usually referred to as the testator, sets out how their assets in their estate should be distributed upon their death. Okay, so this document that the testator then sets up guides the executor when that testator passes on how to distribute their assets according to their wishes. Okay, why is this important? Well, it's important when you do estate planning because it has a lot of different purposes. So other than guiding your executor or the master on how to distribute your estate, we can also use it for various other reasons. Some of those reasons include appointing guardians to protect the interest of minor children, minimizing family disputes that might arise after death, providing legal and financial protection for your loved ones, and also potentially reduce any tax implications on death, like capital gains tax or estate duty. Okay, we do also know, of course, if you do not have a valid will in place, your estate will be distributed in terms of the Intestate Succession Act. And if we follow the Intestate Succession Act, we know from our previous webinar that the results might not always be what the testator intended. Okay, so it is important that you have a will in place to protect the interest of your loved ones and also to ensure that your estate planning is done the best way possible. Okay, what are some of the main formalities that we have when we are drafting a will? So we do have certain formalities that must be met. Okay, so these formalities are a general guideline, but they are strictly applied. So we need to adhere to all of these formalities in order for that will to uphold on date of death. Otherwise, there's always the risk that someone can try and invalidate that will. And of course, if the will is invalidated either in whole or in part, the Intestate Succession Act would apply. Okay, so what are these formalities? First off, the will must be in writing. Okay, so it doesn't have to necessarily be written out in pen, but it has to be written on a document. Okay, the testator must sign the will at the end of the will. Okay, so the requirement states that the will must be signed at the very end of that will. Of course, it's always a safeguard to also initial each and every page of that will when it extends past one page. Okay, the signature must also be made in the presence of at least 2 competent witnesses. Okay, so who signs? When the will is signed, it must also be done in the presence of 2 witnesses, and those witnesses must also sign the will. The question often comes up, who can those witnesses be? So there is often debate that certain beneficiaries or the executor and such, if you receive benefit in terms of the will, you aren't allowed to sign as a witness. There's no express provision in South African law that disallows beneficiaries from signing the will as witnesses. But of course, the general recommendation is to avoid any disputes arising after date of death. It's always on the safer side to not have anyone who benefits in terms of the will sign as a witness on that will. Okay, lastly, we also need to consider the mental capacity of our testator. The testator needs to grasp the reason for making the will and the effects of that will. So they need to have the mental capacity to draft a will and also understand the nature and effects of drafting that will. Okay, so in short, the will needs to be in writing, signed at the end of it by the testator in the presence of 2 witnesses who also sign that will, and the testator must, of course, have the mental capacity to understand the effects of that will. Okay, so these are main validity requirements that we follow. When we look at our legislative framework, we can also see how the courts have applied these various aspects of our validity requirements. Okay, so first up, we obviously always look to our Wills Act, as I've mentioned. And in our Wills Act, we can specifically look at Section 2, which deals with these 4 requirements that I just set out in our previous slide. And this will also be the measure that the courts use to determine whether a will is valid or whether it needs to be invalidated. I also mentioned our Intestate Succession Act over there, because this will come into play where the person dies without a valid will or the will has been invalidated. Okay, there's of course also an interplay between these 2 acts. So say, for example, you have drafted your will and the will has not been invalidated, but in the will you did not, for example, dispose of all the assets in your estate. Those assets that aren't specifically dealt with in your will then be governed or distributed in terms of the Intestate Succession Act. So it is also very possible that these 2 acts can interplay with one another. So it's also it's important to consider when you are drafting your will that you deal with your entire estate.
Gavin, Georgia, sorry to interrupt. I just want to make sure you use the word invalidated the will. But
Yes,
that might not be the will in its entirety. So what you've just said is that invalidation could be a portion of it. Do I understand you correctly?
that's correct, George. So of course, when we look at the validity requirements that we've just looked at, if any of those requirements aren't met, it's very likely that the entire will be invalidated. But as we move through the webinar, as we get to our sections where we have clauses that you aren't allowed to include in the will, those clauses, for example, won't invalidate the entire will. They will only invalidate that section of the will that has those set clauses in that aren't allowed. So then the rest of the will might still be valid and enforceable, but certain sections in that will no longer be valid. Okay, so let's look at some of our case law that has dealt with these various requirements for a valid will. The first one that comes up is also one of our more recent ones, is Shabalala versus Shabalala, which was a 2020 case. Okay, in this case, the main question was whether the will was signed. The will was not signed in the presence of the two witnesses, but one witness was present, and it was signed by another witness after the fact. The question before the court was whether this should invalidate the will. The court examined the formalities in terms of Section 2 and upheld that the importance of strict compliance with Section 2. So there is a strict requirement that the will needs to be signed in the presence of the two witnesses, and failure to meet this requirement will invalidate the will. Okay, so you can't have the will signed and then have the witnesses sign after the fact. They have to sign while you are signing that will. Okay, our second case we can look at is McDonald versus the master. This case focused on the testator's capacity, okay, particularly whether the testator had the necessary mental capacity to understand the natures and effects of making the will. So when this case came to court, it was brought on the basis that the testator did not have the necessary mental capacity, and that should invalidate the will. The court found that testamentary capacity is crucial, and in the event that it's found that the testator did not have the necessary mental state to appreciate the effects of the will while it was drafted and signed, the will's validity can be challenged, and it will be invalidated if it's proven that the testator did not have the necessary mental capacity. Who does the onus of proof fall on in this instance? So the party bringing that challenge to the court will also have to prove that the testator did not have the necessary mental capacity. Our next one would be Beckett versus Nordia. In Beckett versus Nordia, the court was faced with a challenge of undue influence when drafting the will. So the parties approached the courts and they were of the opinion that the testator was unduly influenced when signing the will, and that certain provisions in the will were not voluntary and not the testator's wishes. Instead, they were made under pressure from another party who was also a beneficiary in the will. The court then found that a will must be drafted free of any undue influence, and if undue influence is proven, the will or certain clauses in the will be invalidated. Okay, lastly, we look at Cutts versus Cutts. Okay, and Cutts versus Cutts dealt is specifically with Section 2(3) of the Wills Act, which allows for condonation of wills that don't meet all the formal requirements. Okay, so we have looked at our formal requirements now. It's not necessary to, it's not, the will isn't necessarily invalid if you don't meet all of the validity requirements. It would just be valid from the outset. It is still possible for you to approach the court in terms of Section 2(3) to have that will declared valid if it does not meet all of the requirements. Even though those requirements, as we've seen in our previous case law, are strictly applied, there are instances where the court will declare the will valid if all the parties that benefit from that will are in agreement, and we can look at surrounding factors which prove that that will was intended to be the last will and testament of the deceased. Okay, so the court basically stated in Cutts versus Cutts that even though the will might not meet all of the formality requirements, if we can ascertain that it was indeed the final wishes of the testator, then they might still validate that will and accept it.
Gavin,
So that then just some legislative.
sorry
Yes,
to
George?
interrupt, Gavin, but before you go to the next slide, I can't help but just think it's just a comment. Looking at that Becker versus Nadir and the doctrine of undue influence, I just immediately thought back of that thing that comes out of the old Roman Dutch law, de bloedige hand neemt geen erf. And that, of course, if you cause the death, um, criminally, you aren't entitled to inherit at all. And I just remember that from my university days. I thought I must
Yes,
just that kind of matches up with a.
it does kind of match up, even though you might not be directly involved in the death. Undue influence, I would state, is probably
Yes,
just as bad.
there's someone has added there the bloody hand rule. Yeah, quite
Yes.
cool. Thanks. Sorry to
And
interrupt.
yeah, I also just wanted to mention, George, if you are looking for any of this case law or all of the legislation that we've looked at, I'm not sure if they've popped up our poll yet, but it is available in LexisNexis Practical Guidance Trust within the States as well. You can find all of that information there. I'm not sure if they just want to pop up that poll. If you are interested in being contacted regarding that product, you can just give us an indication on that poll.
Thanks, Gavin. I see that poll is up. Yes, and I mean I thought about that. If I look at that 1953 Act, the Wills Act, and you mentioned in the beginning about all the amendments that have happened over the years. And that just is so important to make sure that you are reading and referencing the up-to-date legislation. So LexisNexis, of course, helps you with that. We ensure that you always have the latest and greatest version of the legislation that is applicable to the work that you do. So please complete that poll so that we can help you to make sure that you use the correct reference works. Thanks, Gavin.
Perfect. Thanks, George. Okay, I think I'm going to move on so long. So now we've looked at our legal requirements. So we've got our requirements in terms of Section 2 of our Wills Act. But as you've seen in the case law, there were some other requirements that also popped up. They weren't expressly stated per se in Section 2 of our Wills Act, but these are also important considerations that can invalidate the will if they aren't met. Okay, so our first one that we look at here is about, of course, our legal capacity. Okay, so the testator needs to have the necessary legal capacity to draft and sign a will. Okay, in terms of Section 4 of our Wills Act, there's a minimum age requirement to have the necessary legal capacity, which is 16 years old. So you need to be at least 16 years old in order to draft and sign a will. Okay, so there's no exception to this rule. Even if you are an 11-year-old billionaire, you still can't sign a will up until the age of 16. Okay, the secondary requirement for legal capacity is, of course, also that the testator must have the necessary mental capacity. So we briefly looked at this in one of our pieces of case law. What this means is that you need to appreciate the action of creating a will and understand the implications of your decisions in that will. Okay, so this will exclude people who have been declared mentally incapable by a healthcare professional. Okay, so there needs to be proof that you are mentally incapable of appreciating the nature of drafting a will. Okay, the testator must also grasp the legal effects of the will, so including how their assets will be distributed and who will benefit from their estate. Okay, so this seems like it's very close to mental capacity. However, there are instances where you can have the necessary mental capacity to draft a will, but you would not necessarily understand the effects of that will. Okay, so if we do deal with someone who does not necessarily have the education to understand the effects of certain provisions in their will, those provisions can also be invalidated if we can prove that they did not understand or intend for those effects. Okay, so these, although not strict requirements like the first ones we saw on the validity of the will, these are all grounds to challenge the validity of the will. So if any of these are not met, any of your beneficiaries or any interested party after date of death can challenge the validity of the will. Okay, our next section that we also need to look at is the voluntariness and the testamentary intent of our testator. Okay, so here we have to look at whether the will was drafted freely, without being coerced or pressured by others. Okay, so that we know that it is the true intention of the testator. Okay, we also need to check that the will was created without any undue influence from others, meaning no one should have had a part in persuading or manipulating the testator's decisions. The testator also needs to clearly express that it is their intention to deal with the assets as they have indicated in their will. Okay, so you can't, for example, reach into someone else's intentions. So if you draft your will, you need to clearly state that it's your intentions to deal with that asset. You can't, for example, instruct someone else to decide how an asset will be dealt with. It needs to be the testator's intention. Okay, and the testator must then obviously provide very specific instructions in the will regarding their assets and the beneficiaries who will be entitled to those assets, as well as how the estate needs to be managed. Okay, so from the voluntariness and testimony intent, we can see that the will also needs to clearly state that there is no undue influence, it's made freely, and it needs to express all of the testator's intentions with specific instructions regarding the assets and the administration of the estate. Okay, again, these aren't necessarily strict requirements, but these are grounds for invalidating the will after date of death. Next up, we look at the electronic signing of a will. Okay, so this is also an important question that we get, obviously, now in a modern world where we are all technologically driven. A lot of the things that we do in our day-to-day life are online. So, of course, it poses the question, can we draft and sign our will online? If we look to the Wills Act, as of now, the Wills Act does not specifically provide for the electronic signing of wills. And the traditional requirements for executing a will in writing and physically, both the testator and the witnesses, is still strictly applied. And this is also when we submit the will to the masters are usually requested in the original to verify that those signatures have been signed physically. We did introduce the Electronic Communications and Transactions Act in 2002. And this act, of course, provided a framework for a lot of important documents to be signed electronically. Unfortunately, this act did not make provision for wills to be signed electronically. So if we look at the act, specifically Schedule 1 of the act, it expressly excludes the Wills Act from its application. Okay, so even though the Electronic Communications and Transactions Act allows for the signature of a lot of documents electronically, it does not allow for our wills to be signed electronically. Is it the end of the road if a will has been signed electronically and we don't have a physically signed will? Not necessarily. So if we look at Van der Merwe versus the Master, this case went all the way up to the Supreme Court. And the court in this instance accepted a will that was signed electronically by the deceased and emailed to one of the beneficiaries for safekeeping. The court, when analyzing this, placed specific emphasis on the intention of the testator. So even though it is a legal requirement that we sign the will physically, if you can clearly indicate that it was the testator's intention that the document was their will, the court is willing to accept the electronic signature of that will.
Yeah. Gavin, George, sorry to interrupt. It's really, really important that, I mean, that Van der Merwe versus the Master, I mean, it's an absolute exception, and an exception will never become the norm. It's very, very important for all of you who are drafting wills and you think, but hang on, digital signing, you're identifying the person properly, the intent, everything is in place. But if you look at the schedule of ECTA, the Electronic Communications and Transactions Act, like Gavin mentioned, it is specifically excluded. So it is really of utmost importance. And I do agree, and I am of the opinion that if ever there was a piece of legislation that ought to be changed, it must be this Wills Act of 1953 to provide for electronic signing. But as we speak here today, you may not sign it electronically. And that's not applicable to today's topic, but included in that Schedule 1 of ECTA, you will also see reference to the Alienation of Land Act, which means deeds of sale, so sales of fixed property, cannot be signed electronically either. That is what the law currently says. So, Gavin, I'm glad you mentioned this electronic signing paragraph here, because it is something that comes up a lot. The same applies to wills done by way of video or movie, that kind of thing. You cannot do that. You have to apply the Wills Act of 1953. So it's very, very topical, and I think it's probably quite high up on the legislators' to-do list, is to bring those amendments to the Wills Act. Gavin, back to you. Thank you.
Yeah, thank you so much for emphasizing that, George. Yeah, I do think it is important, again, just to note that this is an exception to the rule. In general, the court is very unlikely to accept an electronically signed will, as well as the master's office. Very unlikely to accept that will. As you can see in this instance, it had to go up all the way to the Senior Court of Appeal, which is not only a costly process, but also a time-consuming process. So if you are drafting the will, please ensure that it's signed physically. It's not worth the risk of having that will signed electronically. Yeah. Okay, so now we have looked at our validity requirements and also our requirements that can challenge the validity of the will after date of death. Now we can move over to some of our clauses that we get once we are drafting the will. One of our important clauses, of course, being our executor's clause. So in a will, a testator can choose any person they trust to act as their executor in their will. Okay, so this person does not necessarily need to be someone with estate experience. It can be a close family member. The nominated person must just have the legal capacity to act as an executor. Okay, so we've looked at legal capacity. There's an age requirement. There's a mental capacity requirement in order for you to have the necessary legal capacity. Okay, if there's no executor nominated in the will, the Master of the High Court will appoint an executor which is nominated by the next of kin. It is also, of course, advisable to always include an alternative executor if you do have an executor in the will. Of course, there might be a reason why that specific executor that you've nominated does not accept their position as executor. And if you do have an executor nominated in the will, it just provides for a smoother administration process. Okay, it also reduces the time that is required in order for the executor to be appointed. Important to note on your executor's clause as well. In most instances, the master will request that an executor provide security. Okay, so this the master does so that if the executor does not necessarily act in the way that they should as executor, the master holds security. Okay, but you can exclude or dispense of the security in your will. So if you are using a close family member as your executor, for example, and you know that they would not have the necessary funds or access to a bond required by the master, you can expressly state the is directed to deals of such
Gavin, George,
requirements.
Gavin, George here. Sorry to interrupt.
Consideration that we do.
Gavin, George here. I don't know if you can hear me. You're breaking up again a bit, Gavin. Just if you could move around a bit. We just check, we can still see your screen. Let's just do a voice check, Gavin. Gavin, 1, 2, 3. Okay, I'm gathering you. The audience can hear me still. Just say yes if you can hear George, please, on the chat, so that we know that it's yes.
Yeah,
Thanks.
yes.
Thanks, Caroline. Gavin, are you back?
I'm
No, it's still not quite back. Gavin, just
still here. Can you hear me?
there we go. Okay, carry on.
No,
Let's
can you
try.
quite see it? Maybe. Okay, let's try now. Can you hear me clearly?
Yes, okay, and you'll just make your screen on presentation mode, Gavin.
Perfect.
Okay, try again.
Okay, so I'm just going to go ahead with our executive security section again. So like I've mentioned, when you do appoint your executor in terms of the will, it's important that you also consider appointing an alternative executor in the instance where that executor can't fulfill their duty. Another important consideration is, of course, also the security. In most instances, the master will require security from the executor unless you expressly dispense this requirement in your will. So when you are electing your executor and it's going to be a close family member who won't necessarily be able to afford that security or obtain a bond to cover that security, always include a clause in your will where you direct the master to dispense of that security requirement. Okay, we also need to consider the executor's remuneration when we are appointing the executor. You are allowed to include a fixed percentage or amount for the executor to administer your estate in terms of the will, failing which this will be determined in terms of tariff, which the tariff which we get in Regulation 8, at the moment being 6% for the estate, and 6% for any income and expenditure after date of death, and 3.5% on the gross value of your assets in the estate. Okay, but this can be amended to any percentage that is reasonable or any amount that is reasonable in your will. If the master does find that the amount you fixed in the will is unreasonable for the amount of effort required to administer the estate, he can always adjust it upwards or downwards, depending. Okay, so when drafting your executive's clause, just in summary, always include an alternative executor, dispense with the security, and fix the remuneration if you so please. Okay, next up, we look at two other important clauses. So we know the intent of the will is to deal with our assets in the estate. There are two main ways that we can deal with our assets. The one is in terms of bequests or legacies, and the other is in terms of residual heirs or a residuary clause. Okay, so what's the difference between these clauses? With our bequests or legacies, we are dealing with specific assets and specific beneficiaries. Okay, with our residuary clauses, we are dealing with the remainder of our estate. Okay, so let's have a closer look there. With bequest or legacies, we are taking a specific gift or asset, such as money, property, or personal items, and we are granting it to a specific individual or organization. Okay, so we'll, for example, read in the will that my property situated at will be left for my surviving spouse, Jane Smith, ID number so and so. So there will be an express indication of which asset will be going to which beneficiary. Okay, we do get different types of these bequests. We do have general bequests, which I've mentioned involves a certain gift or certain asset that goes to a specific beneficiary on date of death. We do also have conditional bequests. So with our conditional bequests, it's again an asset to a specific organization or beneficiary, but they will only be entitled to this asset upon fulfilling a certain condition. For example, when they reach a certain age or when they complete a milestone. Okay, so you can, for example, leave a special request in your will stating that once my daughter has her first child, she will receive ownership of the property. Okay, so these are all conditions that you can place in your will. We also have our residuary clauses. So these clauses will allocate the remainder of our estate. So in this clause, it's more of a general clause, just so that it covers all of your assets that you haven't dealt with in terms of your bequests. Okay, so this is either to a person or persons, a group or a charity. And this will then deal with the remainder of your estate. So you'll read that the remainder of my estate is to be split equally or in 2/3 and 1/3, depending how you'd like to do that, to the specific beneficiaries listed. And then you would list your beneficiaries. Okay, so it's important to have a residuary clause in your will, just so that any assets you don't deal with are dealt with in terms of that clause. Okay, another important clause that we need to consider when we are drafting the will is our guardianship clauses or our testamentary trust provisions. So these won't necessarily come into play if there aren't minor children involved in the estate. But if there are minor children involved, then it's always important that we include our guardianship clauses or our testamentary trust provisions, where we nominate a guardian to take care of the minor children and ensure their welfare. Okay, it's important that the guardian you nominate should be someone that you trust and that you know are capable of handling both the emotional and financial responsibilities of raising a child. Including an alternative guardian in this clause is always advisable in case the primary guardian is unwilling or unable to act as their guardian. Okay, it's also important to include any testamentary trust provisions. So nominating a guardian is not enough to ensure the welfare of the children. If there are any assets that children are entitled to, you also need to create a trust in your will. If there is no trust created in your will, it's almost impossible to create a trust after the fact. Okay, so the trust we put in place, why? So we put this in place to manage the assets that are allocated to the minor beneficiaries so that the guardian or the trustees appointed to that trust can take care of the children until they reach the age of maturity. What happens if we don't include trust provisions? If we don't include provisions for a trust, those assets will be paid over to the guardian's fund, and our guardian will then have to apply to the guardian's fund each and every time they require a withdrawal on behalf of the children. And as we know, this can be a very time-consuming process, which will often impact the welfare of the minor children. So if you are dealing with minor children in the will as well, always ensure that you have not only a guardianship clause, but also a testamentary trust provision. We will be looking at a template of a will where we do have these provisions in, and then also give you a bit of view of how we incorporate those provisions into our will. Next up, we look at our revocation and amendment clauses. Okay, so of course, there is often a change in circumstances as we move through life, and the will that we've drafted 10 years ago might not be applicable to our recent situation. So it is important that we update our will often. And when we update our will, we need to consider how that will is updated and amended. It's always important that we consider a revocation clause. So what a revocation clause does is it cancels all of our previous wills and codicils, ensuring that the latest will is legally valid and enforceable. What happens if we don't include a revocation clause? Say, for example, in a previous will, we dealt with certain assets, and now we draft a more up-to-date version of that will, but we did not revoke our previous will. In this latest version of the will, we don't deal with all of our assets, but in the previous will, we did deal with all of our assets. Just drafting the new will is not going to invalidate all of the previous will. So if there are certain conditions that we did not, assets that we did not deal with in our latest will, those sections of the previous will still apply unless we have a revocation clause. Okay, so a revocation clause is usually included just to ensure that there aren't any other wills that come into play and complicate the situation. Okay, you can amend a will with codicils. So what is a codicil? A codicil is an additional document that we add onto our will. So we don't necessarily have to redraft the entire will. We can also just include the amendments and changes by adding an additional page or an additional document onto our will as a codicil. It is also important to consider here, though, if you get to a point where you're just adding numerous amounts of codicils that could complicate the reading of the will, it's obviously a better choice to just take all of those codicils and incorporate them into a new version of the will. Okay, so important about revocation and amendment, always revoke previous wills when you are drafting an updated version of a will. You can update your will with codicils, but it's always advised that when you reach too many codicils that you rather redraft your entire will. Okay, we can also look at burial instructions in our will. So burial instructions is a clause that we can include in our will to specify any of the deceased preferences after death. So they can specify their preferences for funeral arrangements, burial locations, the choice of religious rites, and any specific ceremony preferences. Although it is advisable that these are discussed with family members or the executor, as these provisions won't be legally binding. So even though you can include burial instructions and preferences into your will, the parties administering your estate won't be bound by those instructions. So it's advised that you always ensure that those instructions are left with loved ones and the executor of the estate to ensure that they are met. Okay, lastly, we'll look at collation. So collation is also quite an important clause that we include in our will. Collation is a process where if certain gifts were advanced to heirs during the testator's lifetime, they need to be added back into the estate before the final distribution to ensure fairness amongst the heirs. Okay, so the purpose of collation then is to equalize the inheritance, preventing the situation where one heir receives more after taking previous gifts into account. Okay, so important to note here, collation applies by operation of law. So collation will always be applicable unless it is excluded in terms of the will. Okay, so if collation is required, there's no need to include any additional clauses in the will, but this will also result in the heirs having to return the value of any advancements they received during the testator's lifetime in order to equalize the inheritance amongst the beneficiaries. So this usually only applies to immediate and blood relations. So like the children of the beneficiaries, it won't extend to all beneficiaries. Okay, but important to note that if this is not the consequence that the testator desires, collation needs to be excluded in terms of the will. Okay, so these are just some of our common clauses in a will. Let's just look at some special considerations that we need to take into consideration when we are drafting the will. So there are certain considerations that we need to take note of. One of our main ones being our inheritance rights. So even though you do have freedom of testation, there are certain pieces of legislation that allow for claims against the estate, even where they are not dealt with in terms of the will. Okay, so one of these acts is our Maintenance on Surviving Spouses Act. And even if your will does not expressly provide for any beneficiary, for any surviving spouse to benefit in terms of the will, they will still have a claim in terms of the Maintenance Act against your estate where you were married in community of property. So this claims ensures that the spouse receives adequate support, and this will automatically apply even if it's not included in your will. And this is also something that you will not be able to exclude in terms of your will. The same applies to our Children's Act. So where you have minor children, they also have the right to maintenance, so they can claim maintenance against the estate to ensure that their financial needs are met, even if you do not provide for maintenance in the will. And of course, this also means that your children can't be disinherited completely in your will. So even if you do provide a clause in your will where you disinherit one of your children completely, they will still have a claim against your estate in terms of the Children's Act. Our Intestate Succession Act, of course, also applies. So in cases where the will does not provide for all assets, this I have explained previously as well, but where the will does not provide for all assets, the Intestate Succession Act will apply, and it will follow the rules of intestate succession. So even if you excluded certain of your beneficiaries and other clauses of your will, if it did not deal with all of your assets, those beneficiaries might still be entitled to that asset in terms of the Intestate Succession Act. Okay, what about exclusion of beneficiaries? So you can exclude beneficiaries from receiving any part of your estate or overwriting any of their potential inheritance rights. Like you've seen, there are certain inheritance rights that you can't override. Okay, but if you do wish to exclude any beneficiaries, you can clearly state which beneficiaries you would like to disinherit in terms of your will. Okay, but your intentions need to be legally recognized. Okay, so you can exclude a lot of beneficiaries, but as you've seen, for example, you can't exclude children or surviving spouses from maintenance. And it is also always advisable to provide a reason for your exclusion. So if you're excluding a beneficiary, it is often possible for them to challenge that exclusion. So if you provide a clear reason in the will why they are being excluded, it might reduce the likelihood of disputes or challenges from that disinherited individual. Okay, what limitations do we have on the clauses we can input in a will? There are certain limitations. There are additional limitations that are not necessarily mentioned here, but these are the main limitations we have. So we are not allowed to include any unlawful conditions in our will. Okay, so that clauses that require a beneficiary to perform an illegal action in order to receive a benefit are not enforceable. Okay, excessive or unreasonable conditions. So clauses, for example, introducing excessive restrictions or unreasonable conditions on the beneficiaries. These may also not be included in the will, and if they are often invalidated. So if we think, for example, on a conditional bequest, you can't, for example, include in your will that this beneficiary is only entitled to obtain this benefit if they do not marry their spouse. If they do not marry their boyfriend at the time or their girlfriend at the time, those are too restrictive and unreasonable. You can't include those kind of clauses in a will. Of course, this will have to be contested in court. So it's not necessarily that it will be invalid from the outset, but they can be invalidated and are likely to be invalidated by the court. Conditions against public policy are also often invalid from the outset. Okay, so clauses that contravene public policy. So these are clauses that promote racial inequality, gender discrimination, anything like that, anything that goes against Section 9, Chapter 9 of our Constitution. Those will be against public policy, and they will not be allowed as a clause in terms of the will. Okay, there's the exclusion of certain inheritance rights, like we did discuss at the top, will also not be allowed in the will. So you can't, for example, disinherit your spouse or minor children entirely, because we have other legislation that comes into play there. and they will overwrite any clause in your will to disinherit your children and spouse completely. Okay, and then any contradicting legal rights you are not allowed to include in your will. So if there are any pieces of legislation or legal rights in terms of those pieces of legislation that were specifically incorporated to protect individuals or vulnerable groups, you can't override that in terms of your will. So any statutory provisions will always apply. You can't use your will to amend any existing law. So our law and our limitations and clauses in the will then are our unlawful conditions, excessive or unreasonable conditions, conditions against public policy, exclusions of inheritance, and contradicting legal rights. Like I've mentioned, it's advisable to not include these clauses in your will. If you do include these clauses, the effect won't necessarily be that the entire will is invalidated. Only those sections that have these clauses in the will be invalidated. But then the effect of that would then, of course, be once those sections are invalidated, the assets you've dealt with in those sections will be distributed according to the Intestate Succession Act. Okay, so that then was a quick overview of drafting a valid will, and as well as some of the most important clauses and considerations we need to take into account when we are drafting our wills. Next up, I just want to have a quick look at a standard template of a will. I see we have about 4 minutes left, so I'm just going to run through this quickly. This will be available on our corporate website at some stage. We will send out an email as soon as that page is up. Then you can access that page, and you can download this draft of a will template, and it will include most of the clauses that we've looked at today. Okay, so when we are doing our will, you'll see we've got a last will of, and then we just include a full description of our testator. We include their status as well as their physical address. In the preamble, we can include any preliminary information we'd like to include. Of course, we have our revocation clause here, which will revoke any previous wills. We appoint our executor by adding their full name and description, and we also appoint a successive executor should that executor not accept their position. And in this instance, we're also appointing them as the trustee of the trust. Okay, here we're dispensing of the necessity of security as well. And here we also include that we are applying the prescribed remuneration. And if the executor is a professional, in other words, an attorney or an accountant, they are also entitled to their fees as a professional. Okay, so if you don't include this under your executor's appointment, the executor will not be allowed to charge any additional professional fees above and beyond the executor's remuneration. So important to note, if your executor is a professional and you would like them to be compensated for the professional fee as well, that needs to be included additionally under your executor's section. We have our appointment of heirs. So here we don't have any special bequest. We've just bequeathed the entire estate in equal parts to the children and the late wife. We then have our testamentary trust conditions. So we have our condition for creating the trust. We include that this is a separate trust. We indicate how we would like the trust funds to be invested. We indicate how we would like the capital and income to be used during the operation of the trust. Any prohibitions on the disposal of the rights in the trust, and how our heirs will receive payments in terms of the trust. And as well as any alternative clauses to the trust, limitation on the trustee's liabilities, and our postponement of vesting of inheritance in terms of the trust. Okay, so it's important to consider that we include as much information surrounding the trust as possible. So as we do not have a separate trust deed for our mortis causa trusts, when we create that trust in our will, we need to either set out how that trust will be managed in the will or include an addendum with a trust deed for that mortis causa trust, just to ensure that your wishes are met and that the trustee acts according to the wishes of the testator. Okay, we've also included our guardian section here. Oops. We've appointed the guardian for the minor children, and we've indicated how we would like to deal with our mortal remains, so our burial instructions. And we've excluded collation at the bottom, made provision for signature by the testator, as well as two competent witnesses. Okay, so this is just a brief preview of a will. Like I've mentioned, this will be available on our corporate site. As soon as that is available, a link will be shared with you to access that site from your side. But I do think we are a bit over time. I'm going to hand back to George just to wrap up for us and see if there are any important questions we need to deal with before we wrap up.
Gavin, thanks so much. I mean, I was on the edge of interrupting you, but it's fine. Yes, we are out of time. This template that you've just put up here, there's been a lot of feedback. People can't wait for this template. In the meantime, however, everybody, please be sure that you can go onto LexisNexis Practical Guidance, the Wills and Estates section there, and there are examples and samples of clauses there as well. So please go there and check that out. A lot of the clauses that Gavin spoke about are already available on the LexisNexis Practical Guidance platform. So please go and have a look there. But like I say, Gavin, people are keen to receive this template that you shared now. To the
George,
question.
before we wrap up, just there quickly, sorry, I just forgot to mention that this is also all done in association with our deceased estate administration workflow solution. So we do also have a poll for our Lexis Deceased Estates workflow solution that we're just going to pop up. And if you are interested to be contacted surrounding that, please just give us an indication. Of course, it doesn't necessarily link to what we've discussed today, but when it gets to a point where the will needs to be executed, then of course we have that software available to help you execute that as quickly and effectively as possible. Apologies, George, back to you.
No, that's great, Gavin. Yeah, I mean, it's really important. A lot of the questions that have come up aren't necessarily about the drafting of the will, but more the administration portion of it. And it's exactly there where Lexis Estates can help you in the technicalities of the administration process. But Gavin, one of the common thread questions that has come through, and which one can understand, is the question about remuneration. Where you appoint an executor. So let's say I am appointed as the executor of my sister's estate, and I then don't wind it up myself, but I nominate an attorney. The question then is that attorney entitled to the executor's fee, or is it purely a brief that I give with an agreed fee to that attorney? Do you have thoughts on that, Gavin?
So usually, George, when that is the situation, so the situation is when an agent is appointed, it's usually a requirement by the master. So in a lot of estates where we deal with fixed properties or properties that are a bit more complex, the master will often require that if the executor is not a professional or someone with estate's knowledge, that they appoint an agent to assist them. And in that instance, there will be an agreement between that executor and the agent that they appoint, which is usually an attorney or an accountant or someone in the fiduciary.
Okay, there we seem to be losing Gavin.
And it would then be governed by. So, of course, my.
Yeah. Gavin, George, we're losing your voice there, but we are out of time. but maybe I can just say for those that are still in the audience, a number of questions also regarding beneficiaries that are predeceased and what happens then. So the estate devolving by stirpays or devolving via interstate succession. Those are all very legal questions, and I think a lot of them are answerable from the LexisNexis practical guidance platform. A lot of those would be answered there. And one of the key things that I see here, also people asking lots of questions about specific clauses. And the key thing is to be precise and to be specific. The moment you enter into some kind of vagueness, offering discretionary powers to executors, I think one is entering into a swamp of difficulty. Gavin, are you still here? Can we hear you?
I'm back. Yes, George.
You're back. Okay. So Gavin, yeah, I think we are out of time, substantially out of time. But I was just saying with the questions here, there are a number of questions we will get to, and we will see if we can collate these questions and then distribute them as well, because some of them are really quite applicable. So I think on that note, we need to wrap up, Gavin. We're out of time. Gavin, I want to thank you and I want to thank Jamie Lee, but most importantly, I want to thank all our attendees. I really appreciate your attendance. It shows that there is a great interest regarding these subject matters and a very great concern and the importance of doing things properly and doing things correctly. We have difficulties. Some of the questions are relating to difficulties in accessing the master's office, difficulty with respect to original wills that might have gone missing inside the master's office and how one must deal with that. So those are very poignant problems that we're all dealing with. And there isn't a silver lining answer to all of these questions, but we certainly are trying to help as far as we can. Thank you, everybody, for your attendance this afternoon. Again, Gavin and Jamie Lee, thank you very much. And please look out for the next webinar regarding deceased estates. On that note, wishing you all a good afternoon and goodbye.